Good morning, everybody. Ashley and I are delighted to speak to you about your child find duty under Section 504 and review some recent cases in this area. Although this presentation assumes you're familiar with the basics of Section 504, we will review some eligibility and evaluation requirements since that plays such a big role in that murky question of when to refer a student for Section 504 services. Today, we're going to focus on Section 504 and specifically take a look at 10 cases from 2020 and 2021 with a fun bonus case at the end that Ashley personally defended. So let's jump into the basics. Section 504 contains its own child find requirement. The law says that districts must annually undertake to identify and locate every qualified individual with a disability residing in the district's jurisdiction who is not receiving public education. Section 504's child find requirement for parentally placed private school students do not mirror those imposed by the IDEA. While the IDEA requires the district in which the private school is located to evaluate the child, the Section 504 regulations state that the district of residence is responsible for the child find and evaluations. Districts must take appropriate steps to notify students with disabilities and their parents or guardians about this child find duty. Districts are not bound to certain child find methods, and we'll talk about that more on the next slide. The 504 child find notice is important both for enrolled students and those who are residing in the district who are not enrolled, and this is important. Section 504's child find requirement for parentally placed private school students, like we said, don't mirror those imposed by the IDEA. So now we understand that the child find obligation does extend to privately enrolled students and also to those residing in hospitals and universities within your district boundaries. And it also applies to the special populations that are residing within your district, such as homeless and foster students. As students return to in-person instruction, their parents may be concerned about the repercussions of the pandemic. We may see that for some time on their child's learning. They may raise those concerns with their child's pediatrician or other medical provider and arrive at your district with a prescription for an evaluation. Obviously, a prescription alone doesn't entitle the student to a Section 504 plan, but you don't want to just dismiss the prescription without investigating the student's needs. That could lead you vulnerable to a child find dispute. OCR has recognized that school people are not medical doctors, but that is still information that you need to consider. So what should you do when parents present you with a prescription for an evaluation service or 504 plan or an IEP? You'll want to make sure that you meet with the family as soon as you can, virtually or in person, just as you would before the pandemic. COVID-19 doesn't change that. And then ask them what their ask them what concerns they presented to their child's doctor that may have prompted the prescription. Even before the pandemic, we treated those prescriptions as referrals for assessment requiring a timely response. There's such a low threshold under 504 to tip over the scale of child find. So typically that's going to be your response when you get that prescription. And if there isn't quite enough information there, then you're going to want to communicate with the parents and find out what's going on. And ask whether the doctor based his recommendation on any evaluations he completed. Did he have a specialist do an evaluation? Did the doctor base his prescription on those results? See if the parent can share those evaluations with you and let them know that you would like access to any information they haven't shared with you before. That might shed light on the child's needs, and maybe seek permission to connect with the physician, and then you'll want to discuss assessing the student. Request for Section 504 evaluation upon return from COVID closure. You'll probably have some kids that are starting to return online, maybe at the beginning of the next school year, and you might have parents who request a Section 504 evaluation. You can always decline to evaluate if you don't have any reason to believe that the student has a disability at that point. Maybe you need additional time to collect data, but you want to document any request and those responses. The regs, the Section 504 regs don't include a requirement for notice to parent, but OCR has interpreted that a notice is required. And I'm going to hand it over to Ashley.
Okay, thank you. So now we'll spend some time talking a little bit about the eligibility for Section 504. Rebecca's done a great job kind of introducing the law, and we want to make sure you know what we look at when we're determining whether a student is eligible for 504 services. So to start, I want to say that Section 504 is much broader than IDEA. If you look at this diagram that we have on the chart, you'll see students who are eligible for 504, it's often a much larger number than those students who are eligible for IDEA. And the reason being is, first of all, the way Section 504 is defined, it depends on the functional impact of an impairment and how that impairment substantially limits a major life activity. And so you'll see a lot of students who have different impairments, various diagnoses that may impact a major life activity. And so because of that, the student may be entitled to Section 504 services. Unlike the IDEA, under Section 504, there's no type of age requirements, there's no type of eligibility categories. And so there are so many more students who could be eligible for Section 504 services. And students eligible for special education services under the IDEA may not necessarily be, or they could be eligible for Section 504 services typically. If they're eligible under IDEA, chances are they'd also be eligible under Section 504 because IDEA is so much stricter as far as what's required for the eligibility purposes. But the inverse isn't necessarily true. So just because a student's eligible for Section 504 does not mean that they would be eligible under IDEA, because IDEA has a much stricter approach. So what is a disability under Section 504? To be eligible under ADA or Section 504, a student must be determined as a result of an evaluation to have a physical or mental impairment that substantially limits one or more major life activities. The phrase "has a record of a disability" or "regarded as having a disability" are also factors we look at for determining eligibility. And so those, if you have a record of a disability or you're regarded as having such an impairment, that's meant to reach the situation in which a student either does not currently have a disability, but is treated by others as such. An individual has a record of impairment if he or she has a history of a mental or physical impairment that substantially limits one or more major life activities. Okay, so we've used the term substantially limit. So what exactly does that mean? First of all, I'll say that we want to err on the side of broad coverage when we're determining what substantially limits means. Again, the standards under 504 are not as stringent as they are under IDEA. So you'd be surprised how many students could qualify for these services based on a substantial limitation they have. Focus on how the major life activity is substantially limited, not on what outcomes an individual can achieve. So unlike the IDEA, a student's medical condition doesn't have to adversely affect his educational performance for him to qualify for Section 504 protections. The student's impairment needs to only substantially limit one or more major life activities. And within this chart, we have some examples of what those major life activities would include.
That chart's on the next slide.
Sorry, the chart's on the next slide. So we'll get to that in just a second. So for example, someone with a learning disability may achieve academic success, but may be substantially limited in one or more activities such as reading or writing because of the additional time or effort they must spend to do those activities as compared to the general population. So here is our chart, and this chart gives you examples of different major life activities that a student might be substantially impacted by, and as a result would require a Section 504 plan. When the ADA amendments took place in January of 2009, it really broadened that scope of eligibility, which means it also widened the pool of students potentially subject to a district's child find duties. Don't narrow major life activities to just learning. One key difference between the IDEA and 504 eligibility is in assessing the impact a disability has on a student's educational performance. So, for example, under the IDEA, to meet the criteria of an other health impairment, the student's health condition must adversely affect his education performance. However, under Section 504, the student may be academically successful, yet still be eligible for services. Think about the impact of impairment on socialization, for example. Let's say we have a student with autism. The student's performing well academically, making great grades, doing well on STAR tests, is just showing great academic progress. That student still may qualify under Section 504, even if they are ineligible under the IDEA. Teachers do not see social interaction as a major life activity, but in education, the impact of a social skill deficit can be extremely limiting. Social interaction is a major life activity under the ADA. Although the 504 regulations in the American with Disabilities Act do not list socialization as an example of a major life activity, OCR, the Office of Civil Rights, has noticed and advised that an activity or function not specifically listed in the Section 504 provision can nonetheless be a major life activity. So we just want to emphasize that this is not an exhaustive list of the major life activities that could substantially impact a student. So when we're looking at 504, again, it's a very, very broad scope. So this chart also has some different examples of how a student could be eligible for 504 if there's a substantial limitation of any of these bodily functions. Okay. Whether a student is substantially limited in a major life activity is not a demanding standard. The issue is whether a person's activities are limited in condition, duration, and manner as compared to the average person in the general population. And although it may sound like it, this will generally not require scientific, medical, or statistical evidence. An impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. So think about students who maybe have cancer, but it's in remission. These effects of the conditions or medical care may continue even after successful treatment. For these, 504 teams must look at the impact of the impairment over time rather than just as a snapshot. Congress does not want schools to base 504 eligibility on the impact of a student's condition on just any one day. So again, we're looking kind of at the full picture and how it might manifest at different times. What can be concerning also is episodic conditions like ADHD or seasonal asthma, migraines. Congress says you have to give the kid the best shot of qualifying as possible. The way you do this is to find out the impact of the impairment when it's at its worst. If they would qualify at their worst, they would qualify no matter what day you catch them on. So major life activities and the degree of limitation required. So let's say, for example, a student has a concussion. When a student suffers a concussion, schools sometimes jump to provide immediate interventions through a Section 504 plan or IEP without first considering the eligibility standards. The majority of students with concussions recover quickly within 4 weeks, but in a small number of cases, the effects of the concussion might be substantial enough to qualify the student under Section 504. So apply the essential requirements of 504 eligibility to your team's decision-making process. Take into account how long the effects of the concussion last to help determine if it meets the requirements of being substantially limiting. Consider if there's a change in the student's behavior or academic performance. This could potentially impact the major life activity of thinking, sleeping, concentrating. So again, going back to that chart we showed you earlier, if the student has a substantial limitation on any of those non-exhaustive factors, it might be eligible for 504. Okay, so temporary impairments. When we look at a temporary impairment under Section 504, it's defined as the severity of such that it results in a substantial limitation of one or more major life activities for an extended period of time. So we're looking at a couple factors such as the duration of the impairment and the extent to which it limits a major life activity. There's no specific rule in the 504 that defines what an extended period of time means to qualify as a disability for a temporary impairment. So really the bottom line is if a temporary disability substantially limits at least one major life activity for a period of time that will likely significantly disrupt the student's education, then it's likely that it will fall under this exception of temporary impairment. Broken limbs may or may not be a disability under Section 504. There are a lot of OCR opinions that discuss this issue. And again, they look at the length of time in which the student had a broken leg. And if it's something that seems like it's going to be substantial, for a long period of time, yes, the student may qualify. But if it's something to where they're not mobile for about 3 months or so, OCR has determined in those cases that students were not eligible for 504 services because, again, it was temporary and the duration of time really didn't meet the eligibility requirements. So next we'll talk a little bit about mitigating measures. Obviously, many students are on medication. If a student has asthma, they might have an inhaler. There's different things that they use to try to control the health condition that they have. But under 504, you cannot consider the effects of those mitigating measures when determining whether or not a student is eligible for 504. So essentially, we can't say, okay, this student has asthma, but they take an inhaler every day, so therefore they're not eligible under 504. That's not appropriate under the analysis. We still want to look, how are they eligible? What do we need to do to make sure they can access their education despite the fact that they have an inhaler? You can consider the effects of ordinary eyeglasses or contact lenses in determining whether the impairment substantially limits a major life activity. So that is an exception where we can look at, what the student's doing to better see. So as part of the evaluation process, the 504 team must determine that the substantial limitation is not primarily the result of cultural, economic, or environmental factors. Rather, it's a physical or mental impairment. Remember that's our standard for determining 504 eligibility. So when we're trying to figure all of this out and see, is it an environmental factor versus a mental impairment? I think it's important to interview parents, teachers, guidance counselors to better understand the student's home life, their upbringing, and family. Poverty, for example, could be impacting the student's performance or functioning at school. If the team decided that one of these issues is the primary reason for the student's struggles, the team leader must clearly document the team's reasoning, pointing to specific data when showing that the student's not eligible for 504 as a result. And so next up, we have Rebecca.
You advance. All right, so why might you suspect a disability condition? Here are just a few circumstances that might come up that might cause one of your teachers or educators to suspect a disability condition and need for special education. If you have a student who has poor daily grades, poor performance on assessments, just general academic concerns. It could be something that's not academic in nature. It could be involve the student's health. If the student has had some recent hospitalizations, has had to take frequent trips to the nurse. These are all things that you want to pay attention to. If you've got a student who's starting to incur a lot of absences, start asking, why is the student absent? If it's for medical reasons and it's pretty consistent, you'll want to look into that, and that may indicate you a referral for Section 504, or it could involve the student's behavior. If the student has a lot of discipline referrals, removals, suspensions, and your whatever normal behavior interventions that you've put in place, those aren't successful, then that might also trigger a referral. Social concerns, negative interactions with adults and peers, anything that really is out of the ordinary. Communication concerns, if you have a child that's difficult to understand or who is excessively shy and avoids communicating, in academic or non-academic settings. If a parent or family member has raised concerns, or there's a history of disability, attendance concerns, we've talked about that. Primary referral sources include just about anybody who has any interaction with the student. It could be all of these people: doctors, parents, teachers, counselors, administrators, social workers, anybody. When does the duty to evaluate arise? Like the IDEA, a school district's child find obligation under 504 extends to all children suspected of having a disability, not merely to those who are ultimately determined to be disabled. So according to the OCR, 504 procedures when denying a parent's request for evaluation are essentially the same as those that apply under the IDEA. But 504 does not explicitly require a written explanation of the basis for the refusal. And really, 504 doesn't require much. It's in the regs, it's in the OCR opinions. That's where we learn a lot about OCR. So you all know that Section 504 is starting to look a lot like IDEA. So when in doubt, you can consult IDEA. But we have recommended that you put together some detailed prior written notices in these situations. And remember that the threshold is low. So when in doubt, just make sure you evaluate. Prior to the initial placement of the person in regular or special ed and any subsequent significant change in placement, the district needs to conduct an evaluation in accordance with the established evaluation procedures. So here are just a few cases I wanted to share with you. When does the duty evaluate arise? And so a lot of these, if not all of these, are OCR opinions. Yes, they are. So when a parent provides the school with medical documentation about the student's depression, you get a diagnosis about something, that triggers your duty to evaluate. If you have a student with some ongoing behavioral or disciplinary problems, it's just like the chart we saw earlier. You're going to want to evaluate. If you have a student with cerebral palsy suddenly relying on a wheelchair, that triggers your duty. If you have a new student that's enrolling in your district who you know had a 504 plan previously, but then you didn't actually have the copy in your hands, make sure that you don't wait for that copy. Go ahead and evaluate. You knew they were in a 504 plan, so evaluate. Don't wait to get the copy from the previous district. These are some factors to consider in determining whether or not the student is eligible for 504 services. I'll let you all read that on your own time because we really want to get to the cases. The Section 504 evaluation should be based on information from a variety of sources, again, just like IDEA, teachers, staff members, parent, doctors, nurses. You want to gather information from as many areas. Consider all available pertinent information: records, assessment data, medical reports, attendance records, anything, disciplinary history. And you can use the IDEA evaluation process, but keep in mind that if the IDEA process is not used, you've got to establish a separate process for evaluating the needs of students under 504 that complies with the 504 requirements. Just keeping in mind that Section 504 does have different eligibility criteria. Gather relevant data from all of these sources. All of you probably have forms that you just check a box that you check with these people: parents, teachers, nurses, guidance counselors, observations. You want to gather information from multiple sources. The 504 evaluation is going to be conducted by a group of people, including those who are knowledgeable of the child, the suspected disabling condition, the evaluative procedures, the meaning of the evaluative data, and accommodation placement options. So Section 504 regulations clearly require prior notice when a district proposes to evaluate a student. It's not required. Consent is not required by the 504 regs, but OCR has clarified that the 504 regulations require parental consent prior to the conducting the initial student evaluation procedure. So you'll make sure that you do get that consent. OCR has said that no consent is required for a re-evaluation. Make sure when you are considering eligibility that you're not basing it on a diagnosis alone. A doctor's diagnosis cannot be the sole source of information on which you base eligibility. The regs do require schools to consider information from all of those sources that we referred to on the other slides. Your teacher input is going to be vital for the team to fully understand the students' areas of need in the educational environment. And the 504 plan is a living document that changes from year to year, just like the IEP, and will change from environment to environment. And as a result, it's important to have every single teacher participating during the meeting and contributing input about what has or hasn't been successful in the classroom. And it is like a contract. You need to make sure that you're implementing it with fidelity, but that would be a discussion for another day. And now for the top 10 cases from 2020 and 21. We're here. Okay, so the first case, you can see the citation there, is North Pike. This is a case out of Mississippi, June 1st, 2020. This is an OCR case. In this case, the student's parent notified the campus that the student struggled to stay awake due to certain disability-related needs. Those were not identified in the OCR opinion, but the school was aware of what those were. When the parent felt that the school did not respond appropriately to their concerns, they filed a complaint with the OCR, which ultimately led to the OCR doing a district-wide investigation that wasn't focused just on that student. So that's kind of the big thing with the OCR. They get a complaint from one parent, and that might cause them to investigate all these issues. They're not limited by what's addressed in that single complaint. So during that investigation, the OCR learned that the district's policies provided that a significant restriction on major life activity was required to meet the definition of disability, which you all know is a big no-no from what we discussed earlier. The ameliorative effects of mitigating measures were allowed to be considered, such as accommodations and modifications, when determining whether an impairment qualifies as a disability. That's also a big no-no. And the district's policies required students suspecting of having academic or behavioral disabilities to go through a 3-tier intervention process before being referred for an evaluation. And that's also a big no. There are a lot of cases on there that say you can't let RTI be an excuse for delaying. So the concern in this case rested on the district's restrictive definitions of disability that likely resulted in a number of child fine violations. So the takeaway from this case is when you're examining whether a student should be identified and evaluated under 504, you should advise staff to consider the impact of a student's disability on a range of major life activities, not just learning, when deciding whether to evaluate. A student's disability need not affect her learning for her to be 504 eligible. The misconception in schools, and this is very common, is that Section 504 is only for students with impairments that impact their learning, but Section 504 is about equal access to everything educational on, all of those things that were on that chart earlier, I think on slides 17 and 18. Also, don't ignore parental requests. Act on them. Decide if there is a reason to believe the student needs special education because of a disability. If so, evaluate the student. If not, notify parents of your decision and of their right to an impartial due process hearing.
Okay, so case number 2. In this case, the student enrolled into a school district and had received a report from a private psychiatrist saying that the student would benefit from a 504 plan. And I know we often see this when doctors make these types of recommendations to the school district. In this case, the doctor was saying that he had ADHD and anxiety disorder. So the parent requested an IEP team meeting as a result of this and wanted to do an evaluation. The school district convened a Section 504 meeting instead, and they looked at all of the relevant data, the student's attendance, his grades, his student teacher parent input, medical information, and they determined that the student was not eligible for the 504 plan. It was interesting because the student had several absences. Teachers were reporting that it was a struggle to get the student to class. But despite that, the district said that the student was not eligible for 504 because of his academic progress. He was still doing well in school. And so as a result of this decision, the parent filed a complaint with the state education department. And the department said that the district actually should have evaluated the student under the IDEA. So the department didn't even really have issue with the district's decision with respect to 504 eligibility. The department actually felt like this was a child find situation where the student's absences were so severe, and that the anxiety that parent was addressing and reporting maybe was correlated to these absences. And so a special education evaluation should have been done according to the State Department.
Case 3, Teton County School District, an OCR opinion out of Wyoming. This is a COVID-related case out of Wyoming, also one that has a lot of great language that you can apply to non-COVID cases. In this case, the OCR found that the school district timely evaluated a student with ADHD for Section 504 eligibility during school closures. And in the fall of 2019, the parent informed the teens counselor that he was receiving mental health counseling for depression, but requested that it be kept confidential. When the student began falling behind in his work, the parent requested assistance in February 2020 to help get her child caught up and wanted to look into, that's important, dyslexia. And then the following month, the schools were closed due to COVID. In April, the parent presented a doctor's note with a diagnosis of ADHD and depression. The district responded that it would consider the doctor's note and gather data about educational impact. So all good so far. When this district was forced to shut down its school due to pandemic, they put initial evaluations on hold until the school resumed in-person services due to the difficulty of collecting data and observations virtually. The student was determined eligible for 504 services in May, and the OCR found that was timely. You know, when you consider all the circumstances involved, you know, we were all crazy at that time, right? Trying to figure out, what do? We just got shut down to this pandemic. It's not our fault. What's going to happen? But here's what the district did that I think made a difference to the OCR. They contacted the parent within 3 days of receiving the diagnosis in April and agreed to begin the process virtually within 8 days, and then immediately they implemented support. So I think just the timing of all of this, I think this case is really instructive. I think what's also key is that the district didn't become aware of the student's diagnosis until April, and the parent didn't request a 504 evaluation until that time either. The parent's request, and the OCR says this, the parent's request to look into dyslexia is not the same as a request for an evaluation. OCR found that there wasn't enough evidence of disability earlier than that to trigger the district's obligation to evaluate. So, it's a gray area when, trying to interpret some of these communications from parents. Are they requesting an evaluation? And OCR said no in this case. And then after the OCR issued its decision, this is also interesting. The parent didn't mention dyslexia or reading concerns again after that. When they met for that eligibility determination meeting, dyslexia wasn't mentioned. So you kind of wonder whether or not the parent was sincere in expressing that concern earlier. The OCR indicated that the need for assistance with homework and organization are not evidence of disability, including because of depression. So that's a good case to reference. And if you need copies of any of these cases, just shoot us an email and we can send those to you. Thanks. Ashley.
Okay. So case number 4. This is a North Carolina case in Chapel Hill. In this case, the father had a student with ADHD, and he did not appreciate a district's decision to put the student's evaluation on pause due to COVID. As Rebecca mentioned, crazy times. All districts were trying to figure out what to do with students, how to make sure they were still getting their services. And so in this case, the district decided to postpone or delay the evaluation because of COVID. And then they agreed to finish it after in-person classes had resumed. So the father filed an OCR complaint, and he asserted that the district discriminated against his daughter by starting an evaluation but refusing to complete it. While he acknowledged that the school had closed due to the pandemic, he asserted that when he asked about completing the evaluation, the district stated that it cannot continue while the schools remain physically closed. So Dad got upset by this. He did not appreciate that the district didn't attempt to determine whether it could have completed the evaluation. So OCR responded by acknowledging the duty to evaluate, but they also clarified that districts were not necessarily required to conduct evaluations of students during the pandemic if that evaluation required evaluators to be face-to-face. So in this case, the students' evaluation began less than 2 weeks before the district and schools across the country closed their doors for the rest of the school year. So if you can go back to that time period in 2020, you know how it was and how intense it was. And so, I mean, at that point, 2 weeks before they closed down, that's when they decided that they would wait and resume the evaluation later. So while the OCR investigation was pending, the district asserted that it had resumed its in-person evaluation, and they assured OCR that they were ready and willing to complete the students' evaluation. So ultimately what happened is they entered into a resolution agreement pledging to complete its evaluation and convene an IEP meeting as necessary. And that resolution agreement satisfied any Section 504 concerns. That is it for case 4, so we'll move on to Rebecca.
All right, case 5. What is it? St. Francis area schools. All right, this case, the student's teacher was expressing some concerns that this kid was reading and writing backwards and showing some characteristics of dyslexia. The student was at the time receiving Tier 2 interventions and was meeting grade level expectations and progressing in all areas. His state assessment scores were showing some improvement. The student's intervention team concluded that he was making progress and interventions were effective. But when he came back from the COVID closure in the fall of 2020, all of the students' previously acquired skills had significantly diminished. When the student's scores fell into the high risk range, the district implemented Tier 3 interventions, to which he responded positively. And at that point, the parent requested a 504 plan. And I know y'all are probably thinking right now, we saw that with a lot of kids who came back from that time period. I mean, there was a loss of learning for kids across the board. It doesn't necessarily mean that they have a disability. And that's how the state education department came down on this case. They determined that the district didn't have a reason to suspect that the student had a disability or have a duty to request an initial evaluation because the district's interventions were successful, the student's grades were on level, and his test scores were improving. So I think that case is very instructive because I know a lot of districts probably got some requests when the kids came back and they were having issues. So, and case number 6, Ashley's going to talk to you about this.
Okay. So this is another case where it's child find issues. The parent was challenging the district's ineligibility decision. The student had ADHD and autism, but despite those diagnoses, the district found that the student was ineligible under either 504 or IDEA. And so what ultimately happened is the parent requested an IEE, and so this district still did not adopt the eligibility, and the parent filed a lawsuit against the district. And so a key point to remember, I know we've talked about this a lot today, but just want to emphasize that a medical diagnosis alone does not suggest, or some type of evaluation that's the parent gets from the independent evaluator doesn't necessarily suggest that the child is eligible under 504 or the IDEA. In this case, the student was progressing. He had improved his writing, his reading, his communication skills, academic and behavioral interventions were available in the general education setting, and those were working and helping the student access the curriculum. And so the hearing officer found that there was no violation under Section 504 or IDEA.
All right. Case number 8, Douglas County School District. This is So here's the situation. In May 2019, a shooting occurred at the school attended by a student with a central auditory processing disorder. And when the school reopened, the student said that he was afraid to return. The school counselor checked in with him every few days to address his anxiety. That's a good thing. The student's anxiety diminished, but he continued to earn poor grades. Parent expressed concern and requested an evaluation. The district convened a team who determined that the student would be ineligible for 504 plan because his grades were consistently poor due to lack of motivation. So that was the basis of the decision. And so you want to ask whether the student whether the disability substantially limits a major life activity, because almost all students, adults, I know I do, have some degree of anxiety, but not all of us are going to be eligible for services under 504. So the question is whether or not the district violated Section 504's child find requirement. And if we had this set up, we would have a poll. So ask yourself, did the district violate it? A, no, because they had no reason to suspect the student needed special education. Or B, yes, the student had a disability that impacted his educational performance. And so your hint is to, again, go back to that definition of disability. Did he have a substantially limiting disability that affected a major life activity? And so your answer is A. If you guessed A, you got it right. In this case, the student received poor grades, but he was receiving poor grades before this happened. He experienced anxiety after the tragic incident, but anybody would experience some kind of anxiety after that. So the district was able to show that it reduced the student's anxiety by temporarily allowing him to meet with the school counselor several times per week. Records from a recent Section 504 evaluation also indicated that the student's poor grades resulted from a lack of motivation to complete work, and the student's grades and attendance remained consistent throughout middle school. So let's say you've got this same situation, but you've got a diagnosis of anxiety and the student has stellar grades, so kind of the opposite. OCR has said that regardless of the fact that a student's grades are good, once you have notice of that diagnosis and the student is on medication due to anxiety, that would trigger the obligation to go through the evaluation process. So remember what Ashley said was a diagnosis alone may not make a student eligible, but it's definitely going to trigger that duty to refer the student for an evaluation. So the threshold is much lower for referring for an evaluation. I'll just, this case is about anxiety. That's a complex and nuanced disorder. It can have important implications on your child find responsibility. Both the triggers for and manifestations of anxiety can vary widely from child to child. While some students will appear withdrawn or shy or have physical complaints, not all anxiety presents this way. Some students may seem disengaged but are merely avoiding situations or tasks that they perceive as anxiety producing. Others may be high achieving students whose anxiety presents in the form of extreme perfectionism. So if you do get that anxiety diagnosis or a teacher expresses concern in that area, consider the impact the anxiety might be having on that child. And when in doubt, collect more data. Maybe request permission to consult with the student's mental health providers. And I'm going to hand it over to Ashley to talk to you about case 8.
Okay. All right, so in this New Jersey case, we had a student who was very violent, engaged in daily tantrums. The administration told teachers to use different kind of techniques to de-escalate the student and to transition him, but those those techniques that they suggested were unsuccessful. The student continued to have problems in this setting. And so the school ended up recommending to parent find a way to evaluate the student. And so they suggested that the parent could use their own insurance and have a psychiatrist evaluate. That's not the kind of language that we want to use when we're dealing with Section 504 cases or IDEA cases. Again, we have the child find obligation as a school district. It's our duty to identify, locate, and evaluate the student. So if we're seeing these types of aggressive behaviors in the classroom and the different techniques that we're implementing aren't working, and then the student may not be accessing the general education, or the student has some type of major limitation under 504 that would warrant eligibility. And so in this case, OCR was looking at it from obviously a 504 perspective and said it's the school's, not the parent's, responsibility to determine whether the behavior stems from transitioning or if it's from a disability. And so that is really important to make sure we're not putting the burden on the parent to do this. As school districts, we have the obligation to go through the evaluation process. And Rebecca talked earlier about what the evaluation entails. Again, under Section 504, it's not as, the process isn't as formalized as it is under IDEA. We just want a group of people who know the student and can look at data.
That's right. All right, I'm going to talk to you about the next couple of cases. This is Glenn County Schools. This is another OCR opinion from May of 2020. And in this case, the school had received a new student. The enrollment records for that student, 7th grade, included a medical diagnosis of ADHD with medications taken at school during lunch. The student was not at that point identified as a student with a disability under 504 or IDEA. And hopefully all of you are thinking right now, well, if we have that information, we're going to refer for an evaluation. But that didn't happen. So the student in 7th grade received 7 discipline referrals, resulting in 18 days of suspension. And then the following year, 8th grade, the student received an office referral resulting in 10 days OSS pending a tribunal hearing. I guess that's their version of a discipline appeal. But there still at that point was no pending referral or even a request for a 504 evaluation. But the campus was smart enough to hold an MDR due to a suspected disability. You all know that you have, you still have to conduct an MDR if you suspect a disability for students who are not yet identified as being eligible under 504 or IDEA. So you want to make sure you're doing that under your IDEA procedures and your 504 procedures. So they did that in this case, and after concluding that there was no manifestation, they did seek consent to evaluate under Section 504. And just FYI, ultimately this kid was found not guilty for whatever the offense was. That's just an aside. The 504 team did find the student eligible for 504 services. October 9th, 2019 is when they had their eligibility meeting, and in the meeting notes there were plans to conduct an FBA and develop a BIP for the kid. But 3 months later, that FBA still wasn't completed, and the parents enrolled the student in a new school to complete his 8th grade year. And at that point, in January of 2020, they contacted OCR. And this ultimately resulted in a voluntary resolution agreement by where the district promised to conduct an FBA, develop a BIP, and to consider compensatory services for their delay. So what's the takeaway here? The district made 2 mistakes that I could see. First, the student came to the district with a diagnosis of ADHD, and after he was enrolled, quickly developed an extensive discipline record. So those 2 things should have put the district on notice to suspect a disability and evaluate. The second mistake, I think, occurred after the district established that the student was eligible for a 504 plan. It should have followed through on their plan, their promise to conduct an FBA and develop a BIP. According to the OCR, a delay of more than 3 months to implement the student's 504 plan may have been discriminatory. So there was no hard and fast conclusion in that case because the district appropriately entered into a voluntary resolution agreement. And our next case has an extensive history. This is Twin Valley School District. This one actually got appealed to a district court in Pennsylvania. So there's a couple you have your hearing officer decision, and then you have the federal district court opinion. And what we're looking at here is we're looking at the students who are exited from IDEA. What do you do with those students? And when they're not found to be eligible any longer under the IDEA. So this kid, at age 3, he was identified as an OHI during preschool. He had an IEP at that time. When he entered kindergarten, the school district evaluated under IDEA and later determined that the student's profile no longer supported a finding of IDEA eligibility for specially designed instruction. The district, and I put in red the things I wanted you to pay attention to because it does have an extensive history. The district at that point didn't offer, and the parents didn't request an individual assessment to determine if the student would be eligible for Section 504 FAPE support. The mother informed the teacher on a regular basis about battles she was having with the student to complete homework. She reported that when the student returned home from school, the student would become emotionally dysregulated, would yell, shove, kick, hit, throw things, break objects, acting out completely. But that was not reflected, those behaviors weren't reflected at school. The first grade report card noted that the student was advanced to proficient on all skills and noted that the student earned the highest ranking in community leadership, collaborative learning, and self-directed learner. But again, the student continued to have these meltdowns at home. The student complained to mom about not understanding reading assignments, and mom, meanwhile, sharing all of this information with the teachers, right? Those meltdowns and concerns that mom was sharing continued throughout the second grade. The parents sought a private evaluation, and the student was diagnosed with a number of impairments, including ODD, oppositional defiant disorder, autism, and intermittent explosive disorder. And the parents shared that report and requested an evaluation, but the consent form for 504 and IDEA services weren't provided. Procedural safeguards weren't provided. The district, they got the report, and I guess they did nothing with it. So then the students promoted to third grade, and meltdowns continue at home. Prior to the start of third grade, the mother shared another evaluation with conclusions showing that the student had executive function deficits in addition to a history of autism. Still, the school did not convene a meeting to review the report or issue procedural safeguards or seek consent to evaluate under IDEA or 504. So the parent made a second request in writing for an evaluation. Did I mention the first? Because there was one request that the parent made verbally, and then she made a second request. So the school at that point held a meeting with the parents and agreed to do some screening, OT screening, and to put in place some general tiered interventions. And the team agreed that if those interventions were not effective, that they would then evaluate to see if the student would need special education support. So the district was never defined what those interventions would be. They never collected data to assess the efficacy of the interventions, and they never circled back for a conference with the parent after 90 days. So mom continues to obtain and share more private evaluations, and then during the spring semester of the student's third grade year, a 504 eligibility meeting was finally held and granted the student a 504 plan. Following that, the student was hospitalized and missed 20 days of school. The district at that point conducted an FIE that showed that the student was doing well academically, no behavior issues at school, standardized testing indicates above average cognitive ability, observations indicated that the student's rate of on-task behavior was greater than the student's peers, and the parents disagreed with the school's conclusion, of course, that the student wasn't IDEA eligible. So I know we see this a lot where we've got parents reporting one thing and the school seeing another thing in the school setting, and that's what we're seeing here. An IEE was conducted, and that IEE agreed with the FIE regarding IDE eligibility, and And that evaluator commented on the huge discrepancy between the students' behavior at home and at school. So what's interesting here is that these evaluations were looking at the students' eligibility for IDEA, and the hearing officer noted she didn't think highly of really anybody involved in this situation. She gave little weight to the testimony of the school witnesses because they didn't follow the 504 eligibility process. They didn't issue procedural safeguards. They didn't call a 504 meeting to review all of those private reports that mom kept bringing to the school. And she also didn't care for the IEE provider because she was so focused on IDEA eligibility and didn't address the student's long history of impairment and whether those impairments impacted a major life function under 504. So you have to look at both. You've got to look at 504 and IDEA, and they were so focused on IDEA. So here we've got a denial of FAPE, and that was affirmed by the federal court on appeal. You do have a child-find obligation under both. And while the two do overlap significantly, a student may be entitled to accommodation that he or she may not be entitled to under IDEA. So here, both the FIE and the IEE didn't consider the student's emotional regulation and sensory needs that fell outside the IDEA's coverage. So these are just a few slides. Are we short on time? We might need to skip. So that when you have a revocation or refusal of consent for services, we don't have time. So you guys read this on your own time. There's some important cases. There's some questions down here that I just want to answer for you really quick. Can the district file for due process when the parent revokes or refuses consent under the IDEA? No, you cannot use IDEA's mediation or due process procedures in order to obtain a ruling that services may be provided to the child. If the parent then refuses consent under Section 504, the student would still have anti-discrimination protections under 504. So just remember that if you've got a parent who just is refusing all the way around, I think you still have, the student's still going to be entitled to those protections. So what I would do in that situation is make sure that you provide the parent with the more detailed prior written notice. Tell the parent if they're refusing consent for services or revoking consent, that what they're missing out on, what their child's going to be missing out on if they revoke consent. Also inform the parents of some potential repercussions, including that their child could experience lower overall achievement, lack of progress in physical functioning, failure to meet grade level curriculum standards, failure to pass statewide assessments, maybe an inability to graduate or a failure to graduate on time. I think that by being upfront with your parents about the potential consequences, you're making sure that they understand what their revocation of consent could mean for their child. And you want to make sure that you include a statement in the prior written notice that if any time they change their mind, that you are ready, willing, and able to resume those services. So I'm going to let Ashley talk about the bonus case, and we'll skip over this. Here we go.
Okay, wrapping up here for our bonus case. This one was actually a case that I did with a partner at our law firm, Mary Schneider Vogel. We represented Cy-Fair in this hearing in 2020. It was a 4-day hearing, and the student was a Section 504 student. She had anxiety and a lot of other medical conditions, and her parents were asking or requesting that she receive an IEP. And so the district did evaluations under the IDEA and determined that she was ineligible for an IEP, and that her 504 plan was effective. And so the parents filed a child find lawsuit against the district, a due process hearing. And the evidence that we presented was just really teacher testimony, explaining how great the student did in class. She had over a 4.0 GPA because of all of the AP classes that she was taking. She scored in the 98th percentile on the PSAT. Parent was also saying that she was really anxious, but the school wasn't seeing that extent of anxiety at school. So yes, maybe she was at home, but again, they weren't seeing it there at school. And their 504 plan that they had in place did address some things about anxiety just because parent was saying that this was a concern. And so Again, the hearing officer ruled in the district's favor and found that the student was accessing the education. She was doing great academically, socially, and because of those reasons, the 504 plan was working for her and she was not entitled to an IEP. So that was a very fun but long case, but hopefully that will help some of the districts because as Rebecca mentioned earlier, anxiety can be a tricky one. It manifests in students very differently. And so look to that case if you ever need any guidance on how to deal with whether it's a 504 plan or an IEP that should be in place. Obviously, it should be used as a reference. Look at your students' individual factors, but it should be a good resource for you.
Yeah, definitely some good language in there. And I think we're probably at our time limit. We wanted to talk about that overzealous parent, but I don't think that we have some time. But if you have questions, this is a common thing that we all experience, and some practical suggestions for you at the end for you to think about. That your homework is to read all of those. And I want to thank you for your attention. I know you guys are having so much fun at TCASE. It's my favorite conference of the year. Thank you for hanging out with us today, and feel free to ask any questions. Hopefully we've saved some time for Q&A. So thank you so much. We appreciate your attention.
Appreciate everyone. Thank you.
Bye-bye.
Bye.